Hi, everyone, and welcome. Thank you so much for joining us today to talk about the road to compliance, essentials for K-12 schools under the new Title IX regulations. I'm pleased to be joined by the other editors of our Title9Insights.com blog, Amy Dickerson.
Hello.
And Emily Tulloch.
Hi, everybody. So I know you all know why we are here today, which is that the U.S. Department of Education issued new Title IX regulations on May 6th. This has been all over the news, as you can see from just a few of the headlines we have pulled together here, and as I'm sure you've been paying attention to as you seek to enter into compliance with the new rules. The schools across the country are scrambling to make changes required by these new rules, which go into effect on August 14th, 2020. So while you have no doubt also seen in the news that there have been legal challenges already filed against the Department of Education over these new rules, and we will certainly be following how those play out in court, unless and until there is a clear ruling saying otherwise, schools do need to prepare that they will have to be in compliance with the new rules as of August 14th.
Yeah, and we've been talking a lot about the new rules on our blog here at Franczek, which is Title9Insights.com. And we also have reviewed the highlights of the new rules in a previous webinar. So today our goal is really not to rehash with you all of the specifics of what's in the new rules. We're going to presume that everyone listening has a basic level of knowledge about the new requirements. But if you do want a refresher on the fundamentals and the new rule after our discussion today, we really encourage you to check out the many materials we've posted on our blog, which again is Title9Insights.com. In addition to the materials that we have posted on our blog, you can also follow the link that we've posted here, which will take you to the recording of our previous webinar on the fundamentals of the new rules. And our webinar today will also be recorded and posted on both our website and our Franczek YouTube channel, which includes all of our video webinar content, not just that relating to Title IX as well. So please feel free to go to these resources and share them with your colleagues and peers as well.
Yeah. So our plan today is to talk about practical questions that we know many of you are having about the implementation of the rules. We know from our initial conversations with school leaders that this is a daunting task and that there doesn't seem, at times to be a reasonable path to get where we need to be. But our goal today is to show you the path to follow toward compliance and to have a game plan, if you will, including a summary of the important questions that you will need to be asking within your institution as you move along to be in compliance with the new rules. We very much welcome your questions through using the Q&A function on Zoom as we have this conversation today. And our plan is to have approximately 45 minutes of content for you today, followed by your responses to your questions.
So before we jump into the road to compliance, we do want to go over the very high points of the new Title IX regulations, which we think will be helpful as a refresher for our discussion today. So I've called it here Title IX in a nutshell. Obviously, it's hard to put over 2,000 pages into a nutshell, but this is our best effort to try to do so. So under the rules, the Department of Education set forth the new standards by which its Office for Civil Rights will be investigating claims that a school didn't adequately respond to sexual harassment. Under the new Title IX regulations, a school board can violate Title IX when there is sexual harassment. So that's the first part of it. I've got that in quotes because sexual harassment means something very particular and it means something very new. The sexual harassment needs to occur in the United States, and the school has to have substantial control over the context of the harassment and the harasser. If an official of the school district who has authority to institute corrective measures on the district's behalf has actual knowledge of the sexual harassment and the school is deliberately indifferent, which means that they respond in a way that is clearly unreasonable in light of the known circumstances, that is going to be the circumstances where OCR is likely going to find that there has been a violation of the new Title IX rules. Now, as Emily mentioned, we covered much of this in detail during our May webinar, so we do encourage you to check that out if you want a much more in-depth refresher. But we are going to talk through a couple of the elements of this right now that we think will come into play during our conversation today.
So as a quick refresher, one of the biggest changes in the new regulations was to narrowly define sexual harassment that's subject to Title IX rules as enforced by OCR, and that's what Jackie was talking about a little bit earlier. The final rules define sexual harassment as conduct on the basis of sex that satisfies one or more of the following categories. So the first is where an employee of the recipient conditions an aid, service, or benefit of the recipient on an individual's participation in unwelcome sexual conduct, which is otherwise known as quid pro quo sexual harassment. And I'm going to skip the second one quickly and jump down to the third bullet point here. And that's where conduct meets the definitions of what are known as the big four types of sexual misconduct that are defined in the Clery Act and the Violence Against Women Act. And those terms are sexual assault, domestic violence, dating violence, and stalking. Now, this doesn't mean that if those types of conduct occur in the K-12 setting that the Clery Act and VAWA now apply to K-12 schools. It just means that if the alleged conduct that meets the definition of sexual assault, domestic violence, dating violence, and stalking from the Clery Act and VAWA occurs, then the Title IX rules must be followed. And so then if we look back to the second bullet point, if conduct is neither employee quid pro quo misconduct or conduct that falls under those Clery Act VAWA Big Four definitions, then the conduct must meet the second standard in order to be covered by Title IX. And that's conduct that we're referring to as hostile environment, sexual harassment. Under the Title IX rules, there is a new, narrower definition than that to which we're normally accustomed for this as well.
That's right. And we have for you here a breakdown of what is in the new definition for what we commonly refer to as Emily said, hostile environment, sexual harassment. So here, the conduct must be unwelcome conduct that a reasonable person would find to be so severe, pervasive, and objectively offensive that it effectively denies a person's equal access to the school district's education program or activity. So under OCR's previous interpretation of Title IX, schools were responsible for responding to conduct that was severe, pervasive, or persistent so as to interfere with or limit a student's ability to participate in or benefit from the services, activities, or opportunities offered by a school. So this standard now is going to cover a fair bit less than what the rules covered before. Now, keep in mind that just because the definition of sexual harassment under Title IX has narrowed, this does not mean that a school has to narrow their definition under their code of conduct. Moreover, schools may still have obligations under state law to address conduct that is severe, pervasive, or objectively offensive, such as schools in Illinois, for example, would have to do under the Illinois Human Rights Act and under the bullying prevention provision of the Illinois School Code. But under Title IX, conduct is only considered hostile environment sexual harassment if it meets the more narrow definition here. Now, Jackie's going to take us through a hypothetical scenario to flesh this out even further.
Right, so let's look at this hypothetical. So shortly after enrolling at a new high school, a female student had a brief romance with another student. After the couple broke up, other male and female students began routinely calling the new student sexually charged names, spreading rumors about her sexual behavior, and sending her threatening text messages and emails. One of the student's teachers and an athletic coach witnessed the name calling and heard the rumors, but identified it as hazing that new students often experience. They also noticed the new student's anxiety and declining class participation. The school attempted to resolve the situation by requiring the student to work the problem out directly with her harassers. So that's our hypothetical. We didn't make that up. This hypothetical was from the bullying guidance from OCR that was issued in 2010. And there, OCR said that based on these facts, the conduct was clearly unwelcome and sexual, and it was sufficiently serious that it limited the student's ability to participate in and benefit from the school's education program. And that was based on the anxiety and the declining class participation. But that was under the old standard. Remember now that our new standard is that the conduct has to be so severe, pervasive, and objectively offensive that it effectively denies the student access to the school's program or activity. And according to the department, that structure is appropriate in educational environments where younger students are still learning social skills and older students benefit from robust exchange of ideas, opinions, and beliefs. The commentary to the rule says a course of unwelcome conduct directed at a victim to keep the victim fearful or silenced likely crosses over into severe, pervasive, and objectively offensive conduct that is actionable under the new rules. Whether or not it's actionable under those rules, though, they say it may be actionable under another part of a recipient's code of conduct, such as an anti-bullying rule. So the question is, first, you'd have to ask yourself, would this meet the Title IX standard? We're going to need to dig into the case law and wait to see if OCR gives us more guidance and decisions before I feel comfortable giving a definitive decision on this. But what I can tell you is that if I were representing a respondent in this case, I would argue that this conduct was not sufficiently severe or objectively offensive, even if it maybe was pervasive. I would at least argue that it shouldn't fall under the Title IX procedures if I were representing them. I think that really highlights that you're going to need to, at least in the beginning, you're going to need to be relying hand in hand with your legal counsel when you're making determinations about whether these new rules apply, because we would want to make sure that we have a good understanding of how far something has to go to be harassment before it's going to trigger these regulations. Because you could have a respondent who claims that you discriminated against them by using the Title IX procedures if the Title IX procedures under law shouldn't apply. Another thing to keep in mind is what the department said with respect to using other policies and procedures. So this might not be sexual harassment under the new rules, but my guess is that it's probably bullying under state law and under your policies and procedures. And so even if you were to determine that you have to dismiss this complaint based on it not falling under Title IX, you would still, in this case, go forward and consider whether this conduct violates some other policy. And then I've also raised as a kind of alteration here, what if the students also made comments based on race, color, nationality, or disability? And I did that because I want to show for you where you're going to maybe have a mismatch. So let's say that you did decide, and I think it would be reasonable, I think this is a very on the line hypothetical. Let's say you decided that this does fall under the Title IX procedures. If the students are also making comments based on some other protected status, you are still going to have to likely meet the lower standard that OCR applied in the 2010 guidance when you're addressing those. And so you're not going to be asking whether it was so severe, pervasive, and objectively offensive that it denied access to the program. You're going to be asking the severe, persistent, or pervasive that it impacted the ability to receive an education. And that also may then require you to use two different investigatory paths in order to decide whether or not the student is responsible. So this is all to say this is extremely complicated, and we are going to be working our way through some of the ways that we think you can address this complication during our road to compliance today.
Yeah, and Jackie, if I can just jump in real quick, when you mentioned, even for example, to your most recent point, when you mentioned earlier that a school might have to dismiss a complaint under Title IX, but still proceed under other policies. If you've heard us perhaps talk before in our other webinar, you'll hear us talk today about sample forms and notices and templates to help you with compliance with the new rules. One of those things would be, to include, for example, a sample notice that says, the school may be not considering your complaint anymore under Title IX or at all, and it's therefore dismissed under Title IX, but will be considered under other policies. And so I wanted to raise that because I think understanding that, we're working to try to help you through your policy revisions and through sample forms and templates, try to make this as practical and as clear as possible. And so that step of perhaps if you need to dismiss an issue or a complaint under Title IX, we're going to be with you to help show you what that actually looks like as you're implementing under your policy, as well as the notifications and communications you make to the parties.
So moving on to what's actually required under these new Title IX regulations if your school knows about sexual harassment, as it's now really defined under the new rules. So the school must respond promptly and in a manner that's not deliberately indifferent. And for the first time, the rules specifically require certain things to be included in a school's response. And that can include significant training requirements to ensure that the grievance process is implemented fairly and correctly, which is the big focus of the new rules, among several other requirements. But this requirement is one of the reasons that we've heard from school leaders and is understandably causing a lot of concern as we're approaching the effective date of August 14th, especially with all of the other things that school administrators have going on right now.
So in order to help with that work, we have put together a roadmap for you, our Title IX Road to Compliance. So we will start out by talking about the team that we suggest you put together to address the task at hand. We will then talk about the key roles that you will need to identify various individuals for under the new rules. We'll then also discuss how you can work to get your policies and other written documentation in good shape for the August 14th implementation deadline. And then finally, we'll talk through how you can tackle the requirements for training that are required by the new rules. And as we stated earlier, we will leave room at the end of the presentation for your questions. So again, please make sure to get those in through the Q&A function on Zoom here. So let's jump right in to discuss the team members you may want to include on your team that have responsibility for effectuating your district's compliance. In other words, those individuals who you need to be involved or on board to get you where you want to be by now and August 14th. So as we just said, compliance with the new rules will require a number of things: making revisions to policies, procedures, student handbooks, updating your website notifications, as well as scheduling and having your appropriate staff complete training, and developing forms and template letters to help you be able to be organized and move efficiently as possible through the policies when a complaint is filed. So starting today, we recommend identifying who are the individuals at your district who are typically involved in revisions of these different areas, as well as who will have information for you to help inform how those different procedures and policies should look, and make sure then that they are aware that you will need their assistance in the coming months. So again, the question to ask yourself here is, who do we need to get everything done that we need to do by August 14th? So when you're thinking about who needs to be on this team, it's likely going to differ district to district and school. For instance, in a large unit district, you may need at least one person from each building on this team in order to help inform how your policy and procedure should ultimately look, as well as to have involved the key people who are finalizing student handbooks, for example, even if the main Title IX coordinator will be the one to give everybody that specific language. It'll be really important as you're developing the substance of your policy and procedures, even if you're, really going to, even if that process looks like you're going to be getting, press's model policy and reviewing that to make any appropriate updates to conform to your particular district or school, it will be important to have a handle on how things are done at each building to be able to inform what your specific school's policies and procedures should look like. So even if the Title IX coordinator and the district level administrators are primarily responsible for getting your district into compliance, you may need to be in close communication with each building for both substantive information on how best to structure your policy and procedures, as well as logistically. For example, to make sure that they have the correct updated student handbook language and website notifications within the applicable time frame, and to make sure that you know their timelines for staff training so that when you're scheduling those, that they all coincide.
Okay, so we were hoping to get a little bit of input from you before we move on to our next slide, and I have some instructions here for how to join in our poll. We're going to have a couple of polls today during this session. So if you are using a phone, the easiest way to do this is to text the name of our firm, which is FRANCZEK, and to the phone number 22333. And there you just are going to send that text message, that'll connect you. And then once we get to the next slide, you'll just vote by putting in the letter of the answer that you want to agree with. You also can do this on the computer by going to pollev.com, and there'll be a box that pops up and you just type in Franczek there. And then once we move to the next slide, it's going to give you the opportunity to respond there. So I'll give a few seconds just for people, if you'd like to join in, which we really hope you will, to send that text message of Franczek to 22333. Or to go to pollev.com and to type in Franczek there. All right, and if anybody needs that information once we move on, you can always send us a question and we'll be happy to type the answer back to you, okay? All right, so moving on to our poll itself. So you'll see, oh, actually the slide has the information at the top, so that's great. So what we were hoping to find out from our participants is, to describe your role, and maybe maybe none of these really fits your role exactly, but we're just hoping to get a flavor of who we have on the call today and what different roles people are playing. So it looks like we have legal counsel. We have human resources, which makes sense because there's a lot of overlap between HR now and these new Title IX rules. We have superintendent, maybe a couple of superintendents on here. Lots of human resources folks. I'll tell you that upcoming, we are going to be doing an HR sort of hypothetical focused blog post. Hopefully it'll be up this week. So for those of you who are in HR, make sure to check out and subscribe to the blog. All right, so we've got a decent representation of different folks here. I will tell you that I used the list of who had registered for the webinar today to create this. And so our webinar list for who signed up included board members, superintendents, business and finance office administrators, human resources, student services, legal counsel, and then also building administrators such as principals.
Great, thanks, Jackie. So when thinking through the issues that I had raised and talked about in terms of who you're going to need to be on board and be in the know to get you into compliance by August 14th, consider all the individuals identified here and how they might play a role at your district or school in the different steps that you need to accomplish between now and August 14th. For example, your board will need to adopt any policy revisions. Your superintendent and other district level administrators would need to be involved in both the preparation of those policies and administrative procedures, as well as be aware of timing to assist with presenting the policy revisions to the board or any policy committees. These individuals may also be the ones to authorize training, which will need to occur. As previously discussed, building level administrators, typically charged with substantive investigations as well as student handbook revisions, may need to assist both substantively and logistically with this process. And any committee, both district or building level, that you may have established to assist with policy revisions, handbook revisions, or training may also need to be looped in, as well as any administrative staff who typically help with finalizing these issues. So consider now, giving all of the identified key players that are applicable for your district and school, give them a heads up now that their assistance, however large or small, may be needed in the coming months. Let them know your anticipated timeline for when they will be called upon to assist, and share your internal process with them. And then provide updates or check-ins as you proceed forward. We think taking this step can help you and your schools and districts get organized. Let everyone know that you are on top of this, that you've got a plan, and that it can really help put these issues, on their radar to know that their assistance may be needed and may be needed promptly when the time calls.
And make sure that you keep in mind the responses to our list of who was present and registered for this when you're putting that list together. That was really intended to show you that there's a wide range of people who are thinking about and should be thinking about these issues.
Yeah, so as Jackie and Amy just mentioned, we've talked kind of now about the team that's going to help you get your train on the track, if you will. But what about the roles that are going to get your district's necessary paperwork in order and completed? And those individuals really fall into these two types of key roles we're going to talk about today. The first is your Title IX administrators, which we're going to explain shortly. And then there's other individuals that we've coined as officials with authority, which we discussed a moment ago and we're going to dig into a little bit more now. So the rules require that you designate the Title IX coordinator. And while the rules don't specifically say that you need to also designate a decision maker at the appellate level, they do imply that that's going to be the case. The rules do so by saying that you have to describe the appeal process, which probably means that you're going to have to say who the district has designated for that appellate decision maker role. Now, designating someone now does not mean that you can't then change them later if you decide you want to use different people. And you could also even consider identifying the role as, for example, the board or designee in your policies. And that way you really have the flexibility to determine on a case-by-case basis at the appeal stage if you want to proceed with an internal decision maker or if you may designate someone externally. And also, regardless of if the decision maker is required to be in your policy, you're going to need to identify who that person or those people are internally anyway, because they're going to need to be trained by August 14th along with everyone else.
Yeah, and as you think through, who these main individuals will be that will serve these roles, consider also identifying alternatives to these individuals or alternates, so that, if the individual who you primarily plan to fill a certain role is unavailable or has a conflict, you will have others who have been trained who can fill these roles if needed, regardless of whether they are identified expressly in your policy. And then, of course, as you are reviewing and making updates to your policy, you want to just keep these, these things in mind too, to make sure that you're aware of how specific your policy is, so that you're aware if it gives you certain discretion to be able to move people in or not, or if ultimately you end up making a more significant change of having somebody else fill a certain role, if that would require a policy update down the line or not.
So now we're going to get into some of those Title IX administrators I mentioned. And the first one's going to be your Title IX coordinator. So designating a Title IX coordinator is nothing new. But what is new is that they specifically need to be called the Title IX coordinator in their title and in your policies. So that means that while they may fill other roles such as, a non-discrimination coordinator or a complaint manager, they can't only be called that. They also need to have the title of Title IX coordinator somewhere in their title. And we really recommend thinking carefully at this stage about who this person is going to be. We know a lot of K-12 schools right now have designated athletics directors as their Title IX coordinator in the past, and that really makes a lot of sense because athletics are a facet of Title IX implementation. But here, keep in mind that now there's a lot of extremely heightened standards for what a Title IX coordinator must know about, sexual harassment, among other requirements, and there's going to be a lot of intersection between different departments like student services and human resources. And keep in mind too that you're also able to designate deputies. It may be a good idea to identify one individual with responsibilities in student services, someone in human resources, and then someone maybe from the athletics department as deputies to cover all of your bases. But ideally, your Title IX coordinator is going to be someone who can oversee all of what Title IX covers. And remember too, for anyone that may be new to the role of Title IX coordinator, or as you're picking this person out, the 2015 Title IX resource guide is still in effect and is a really great resource for anyone who needs to take more of a deep dive into this role.
Yeah. And you definitely still want to have, as Emily said, one person designated as the overall, Title IX, main Title IX coordinator overseeing the school's compliance. And, we often get a question of, well, where is there any one quick place I can go to know what falls all under, the Title IX coordinator's responsibilities? And as Emily just said, that resource guide, the April 2015 resource guide, covers all the areas under Title IX with which a school must comply, not just sexual harassment, which is the focus of the new rules.
Yeah, and so one thing we've heard asked is, do we need to designate multiple Title IX coordinators? And as Emily and Amy have both explained, these decisions aren't going to be something that can be, an off-the-shelf decision. It's going to have to be something that's specific to your district and takes into consideration what your district is like. And, whether you need deputies or multiple Title IX coordinators, it will likely depend on the size of your district, the number of buildings you have, your historical number of sexual harassment complaints that you received, what other responsibilities your Title IX coordinator has. So there's a lot of things that you'll need to consider on a case-by-case basis, and we're definitely happy to think through any of that with you as needed.
So moving on from Title IX coordinators, we have investigators. So these individuals need to be really familiar with the investigation requirements in the new rule, including evidentiary issues, dealing with relevancy, report requirements, and requirements for sharing evidence with both parties, just to name a few. So that means that your investigators should be people that you really trust to fulfill these very detailed requirements. And we know that there's a lot of new requirements being thrown at you right now, but this might be a really great opportunity for you to look at how your district does investigations and what your policies say across the board. And that includes your uniform general grievance procedures. And what I find is that many schools are using deans to do investigations, for example, where the press policy doesn't necessarily envision that, and at least not without a report to the superintendent. But now you really have a chance to make your policies reflect what your district practice actually is.
Yeah, since I came back to the firm from OCR in 2016, I've been sort of beating the drum about the need to do this a lot. And I think now it's even more imperative that you take a look at, almost like an audit of what you're actually doing, because it used to be that a lot of schools were able to move very quickly and just have the deans call in the respondent and talk to them about what has been claimed and figure out a resolution. But now these regulations require a very strict process be followed and very specific people to be involved. So it's just important to make sure, if you want to have those deans be able to do that, or the principal, that you're making sure to identify them as investigators and ensure that they're getting the training that's required by the new regulations.
Yeah, thanks, Jackie. And do note as well that when you're picking your investigator, that person can be the same as your Title IX coordinator. This might be really helpful for smaller districts because it narrows down the number of administrators that you're going to need to fill all of these different roles. We do still recommend, though, that an investigator of each sex is available if it's requested by a complainant or a respondent.
Yeah. So I could see, for example, a large unit district having 2 investigators trained and be ready to conduct an investigation, having 2 investigators at each building, to keep open the option to have building level investigations, which oftentimes is something that districts want to have because they know that those at the building level may, are just more more involved, more aware of who the different individuals are within the school community, as well as how the structures and programs are in place at the school. So it really can differ, and certainly for your large unit districts, having 2 at each building, 1, for example, of each sex, and being trained in case one's unavailable or has a conflict, may be the best approach for some districts.
Yeah, we did receive a question of, our school system has 115,000 students in a number of buildings. What thoughts as to who could be the Title IX coordinator? What other roles would work with the Title IX coordinator role? And I think that's a really good question. I will say that under the old guidance, I would have said, and I don't know if Emily and Amy agree, but I would have said you needed someone who's really good with data and really good with, spotting issues and concerns that might be trends, because we used to have to respond to things that we should have known about. And so we needed someone who was able to be very disciplined. We still have a lot of record keeping responsibilities under the new regulations, but a lot of that data kind of focus has now been shifted, as I see it, to that initial meeting that your Title IX coordinator is going to have with your complainant. And during that meeting, they have to offer supportive measures to the complainant. They have to tell them about the process and to make sure that they are aware of how to file a formal complaint. And so I always think that your administrator, district level administrator who handles student services is a very good choice, because they're usually someone who's very familiar with how to, talk to and work with students. Another option though, a good one, and maybe if you're going to go the dual route that Amy mentioned, would be to have your student services, director of student services, and your director of HR serving as sort of a dual role. And delegating responsibilities, because the new rules do also technically cover employee on employee misconduct as well. So you might want to have your HR person involved in that as well. I don't know, Amy and Emily, if you have any other thoughts.
I think that's right. And I think, we'll talk in a little bit about, that standard that Jackie referenced. And, I think we'll see as the rules are, once the rules do actually go into effect, kind of what we're advising, is the best practice for Title IX coordinators in terms of that data keeping and record keeping. But I agree with Jackie in terms of identifying, the individuals at the district level. And then I think, again, you're at the building level, having people on the ground. I could even see a few different tiers. So perhaps at the building level, oftentimes I see principals or assistant principals maybe the ones that might fill that particular role for doing an investigation and being a deputy Title IX coordinator. For a really big district, it might really help support your schools to have also a middle level too, of having a deputy that is also helping to oversee and support the elementary schools, and then the middle schools, and then the high schools. So I could even see a system where if it's not too unwieldy for you, certainly there's no one size fits all, but if that felt right to be able to have a good pulse on your schools and support them, perhaps you have a couple, 1 or 2 identified at the district level, ones to really help support those different grade level schools, and then someone identified at each building as well to support.
So next up on our team of key roles, so you are going to have your decision makers at the complaint level. So where we talked about earlier, where you could double up your Title IX coordinator and investigator role, when it comes to these decision makers at the complaint level, these individuals cannot be your Title IX coordinator or an investigator. So your decision makers have to be able to make determinations regarding responsibility by applying those evidentiary standards that your district lays out in its grievance process for formal complaints. And the new rules also emphasize that decision makers must be free from bias or conflicts of interest against complainants and respondents generally, or against any individual complainant or respondent, which again was a big focus of these new rules. And they also require training for decision makers on how to perform those roles impartially. So there's a training component to this as well. And then decision makers at the appeal level, kind of like we mentioned earlier. Similar to those decision makers at the complaint level, these individuals cannot be the Title IX coordinator, investigator, or they can't be those those decision makers at the complaint level. So currently, the Uniform Grievance Procedure from PRESS says that the board has the final decision-making authority. So we expect to see a lot of districts wanting to keep it that way. Do keep in mind, however, though, that if board members do remain the final decision makers, that means that all board members then must go through the training that's required by the new rules. And the board may not want to do that. So it isn't required to be the board. We do know that in some cases, including where suspension and expulsion are imposed as sanctions, the board may have some other required role also as a decision maker under state law. So if in some circumstances you want the opportunity for the board to weigh in, you could also build into your policies another layer after the appeal, or maybe even before the appeal, as long as they don't conflict, to have the board come in and actually have that, other layer of review.
And I should say that we assumed in preparing these slides that most of you were going to be eternally grateful to the department that they did not require you to have live hearings and that you were not going to have them. If you do have live hearings, your decision maker at the complaint level can only make that decision based after holding that hearing.
Good point, Jackie. And so rounding out some of the key roles are these informal resolution facilitators, who are going to be responsible for, as their name suggests, facilitating resolution between the parties. And these individuals, again, cannot be Title IX coordinators or investigators or decision makers at either the complaint or the appeal level. But the same anti-bias, anti-conflict of interest, and other training requirements are also going to apply to these individuals.
So yeah, I did the OCR version of this when I worked at OCR, which was first it was called ECR, Early Complaint Resolution, and then it was called Facilitated Resolution Between the Parties, which is the language that's much more similar to what they use in the rules. And a couple of thoughts from that experience. Number one is that you could use, if you have a number of investigators, you could use an investigator who is not investigating the actual complaint to be the person who is facilitating that informal resolution process. And that's what we did at OCR. So I would not do the informal resolution process with a complainant and a respondent in my own case that I was investigating, but I would be called on to do it when another investigator's case needed to go to that process. And the other thing from that experience that I would just like to pass along is that, even though these aren't formal mediations, this is an informal process, you really do want someone who has some knowledge of how to conduct the process, even above and beyond what is specifically required in the regs as far as training. You're going to want someone who's knowledgeable, because there are some very unique processes and ways that you have to work with the parties in order to have a successful informal resolution process. And so again, we are going to be offering trainings, and amongst those will be trainings that address this issue.
Yeah, and although this is informal, there are now rules of what is required, including providing the parties with a particular type of notice regarding the informal resolution process. So whether the parties and the institution is using something like a mediation or something short of that, be aware that there are particular requirements that schools must meet in order to use the informal resolution process.
I wanted to talk through very briefly some hypotheticals about kind of choosing your key role players for the new Title IX rules. So first of all, what if it's a small school district and they only have a few, maybe even only 2 administrators, and they may be thinking to themselves, how are we supposed to find individuals to fill all of these different roles? So thinking through that, your administrator number 1 could serve as your Title IX coordinator. That first administrator could also serve as the investigator. Your second administrator could serve as your decision maker for the complaint, and then you could pull in the Board of Education to be the decision maker on appeal. Now, the biggest issue you're probably going to face if you're this small, or even if you're not this small, but you choose to have this streamline of an approach, is that there could be situations where there are appearance of conflict or bias. So depending on if administrator one might know very well the teacher who has been alleged to have done something, you might have that come up. And then also we might have some issues if the board has to be involved in some way in the decision making on the complaint. So we had a very robust conversation in prepping for this about how Senate Bill 100 here in Illinois is going to come into play, and the board's responsibilities to act on expulsions and to address appeals of suspensions. And so if you're in that situation, you could potentially have some issues where you're not able to rely on the board for the decision maker on the appeal. And then also you might have the question of who's going to handle the informal facilitated resolution if one of those comes up, because all of these people are, used up. Now, you can use external resources and options for some of these roles. So for instance, if you want an investigator or an appeal decision maker, an informal resolution facilitator from outside of your district, our firm will be offering those options, and our investigators will have gone through training required by the new rules by August 14th. So I have a link here to our Title IX page. That's actually going to be updated this week with information about our new Title IX toolkit. And that will have information about forms and documents, but also information about trainings that are available and how we can serve as an external resource for your district if needed. Another option, so taking that into consideration for your small district, could have your administrator number one serving as a Title IX coordinator. You could have an outside investigator from, our law firm or another law firm or a consultant. You could have then your administrator two acting as the decision maker on the complaint with some involvement by the Board of Education if required by state law. And then an outside appellate review, although that would have to be in some way separate from the outside investigator. So you're not going to hire Jackie or Amy to do both of those roles. Now, there's not necessarily a concern with this setup about any conflict of interest or bias, but do always consider that when choosing team members for a specific case. Now, the other option, other end of the spectrum, and I know many of you are going to fall in between, but I think these principles apply equally to anybody that falls on the spectrum. So hypothetical number two is you have a large unit school district with multiple buildings. And this was sort of what our question was about earlier. So one way you could go about this is you have a district administrator serving as the Title IX coordinator. You should consider deputies. I actually do think you probably need a deputy Title IX coordinator who addresses athletics. There's a wide number of schools that have their athletics person as their Title IX coordinator for everything. And then there are many that really aren't thinking about athletics at all. They don't have anyone who's keeping an eye on their equity when it comes to athletic. And that is an essential under Title IX, even though it's not addressed by these new rules. So then you could have a district or a building level administrator, and you could have a wide number of them who are trained to be your investigators. You could have your superintendent as the decision maker, which is what we have now. And you could have your Board of Education as the decision maker on appeal, which is, again, what we have now. But the same issues are going to come into play here about Senate Bill 100 board involvement. And always, we want to consider conflict and bias when we're choosing those team members. So another option might be, again, have your district administrators as Title IX coordinator, building and district level for your investigators. Maybe your superintendent and your board are in some way going to be playing that role as the decision maker on the complaint. And then maybe you're going to have an outside appellate review, like from someone like us. And one thing I'll say about that is if you look at what these appeals look like, they are extremely legal. So even if you're not going to bring in an attorney to do the appeal, I would make sure that you're definitely involving your legal counsel on those decisions, because they are very much like what a judge would be asked to do in a courtroom, of applying the law to the facts and determining whether there's been some kind of error.
Okay, so looking forward under the current Title IX rules, when we're talking about, who else has a big role to play at your school, OCR has, previously used the term responsible employees to describe those individuals whose notice or knowledge of alleged sexual harassment would trigger a school's duty to respond. Now, under the new rules, instead of using the term responsible employee, the new rules and comments to the new rules refer to those individuals whose notice or knowledge triggers a school's obligation to respond as officials with authority. So for all institutions, notice to the school's Title IX coordinator or to any official of the recipient who has authority to institute corrective measures on behalf of the school, referred to as officials with authority, conveys actual knowledge and triggers a school's obligation to respond. For elementary and secondary schools, notice to any employee in addition to the Title IX coordinator or to any official with authority also triggers the school's response obligations. So under the final rules, an elementary and secondary school must respond whenever any employee has notice of sexual harassment or allegations of sexual harassment. And as the comments to the rules explain, notice results when any school employee, any Title IX coordinator, or any official with authority witnesses sexual harassment, hears about sexual harassment or sexual harassment allegations from a complainant, which is the person alleged to be the victim, or a third party, or if they receive a written or verbal complaint about sexual harassment or sexual harassment allegations, or as the comments say, by any other means. So the comments to the rules discuss that, in most instances, if conduct is so pervasive that some employees should have known about it, such as sexualized graffiti scrawled across lockers that otherwise meets the definition of sexual harassment, it's highly likely that at least one employee did know that, did have actual knowledge of it, and that would trigger a school being charged with what is now the new standard, actual knowledge of the harassment, and thus having an obligation to respond. So while under the old rules, a school had responsibility to respond promptly when a school knew or should have known about sexual harassment, under the new rule, there's now this actual knowledge standard. So the key here is especially that because your school district is responsible for the actual knowledge of all of its employees, it's extremely important that all employees know this and know what type of conduct or communication might trigger this responsibility and know who to report such conduct or communication to so that they then do report it to the Title IX coordinator when needed and appropriate. And, for your community, even though we don't see in the over 2,000, pages of the comments to the regulations that we admit we haven't memorized yet, we don't see that you've got to identify them publicly. It's really important for your community to know, how all employees play a role in this and how a report can be made. So most importantly, you should plan to have all employees trained on these reporting obligations, including on what sexual harassment is, to avoid risk and protect students who may be subjected to sexual harassment. Because again, once these employees have actual knowledge based on the notice examples that I described earlier, then even if no administrator is made aware of it, an employee's knowledge is what triggers the school district's duty to respond. And even though a formal complaint now is what triggers a school's obligation to investigate, once a school has actual knowledge of sexual harassment or allegations, that does trigger the overall Title IX process, including that initial meeting with the alleged victim and complainant to let them know of their rights under the policy and their ability to file a formal complaint and to let them know of supportive measures that are available.
Okay, so switching gears, let's talk about policy. We all know that these rules and regulations, that they are going to require changes to policies. And we also know that many of you are likely waiting with bated breath for press or your other policy service to release the policy that hopefully you'll be able to use. But even once you are given a template or sample policy, you are going to have to think through some additional things. And if you're doing this on your own, which we know a number of districts, even those that have access to policy services, are doing just because they don't want to wait until right before go time to make the changes that they need. We just wanted to talk through some of the things that you need to think about. Probably the biggest issue that we've been asked right now is, do we have one policy or two? And I know clients who are doing it both ways, both in higher ed and in K-12. So there's not a right answer. This is really where you're going to be looking at your own campus, your own climate, and your culture to determine what is the best decision to make. There are, for instance, in higher education, some institutions that are saying, you know what, we want to apply these Title IX procedures across the board to any sexual harassment, even sexual harassment that isn't severe, pervasive, and objectively offensive, or even conduct that doesn't occur within the United States. And that's your prerogative. You technically still would have to dismiss something technically under Title IX, but there's nothing to prevent you from using the procedures that are required for whatever you want. That's not something we are going to recommend for, frankly, K-12 or higher education, because you're bringing on yourself a lot of administrative responsibilities that your policies would then promise to complainants and respondents that you would be doing in every case, not just those required by the regulations. The somewhat more common question is, do we put all of this stuff like the, bullying and Title VII employee on employee conduct, and do we put all of that into the same policy, or do we have a complete standalone policy? And again, there's not a right answer. What I would be asking is, what do we need to do for us as far as ease of implementation? If it's going to be an unwieldy, I keep referring to them as choose your own adventures for my favorite books when I was a kid, version of a policy where you're having to hop around and go from place to place and it just gets confusing, that may not be the best thing for your administration. It may be very difficult to actually use in practice. It may be easier to have it completely separate out the Title IX requirements and have different policies for other types of misconduct. But do keep in mind that if you are going to be sweeping anything under these Title IX processes that aren't required to be there, we do see a significant amount of burdens imposed by the rules. It is going to take resources and time to implement these practices. So just keep that in mind as you're thinking through these questions. So we actually did have a question, a poll to do as to whether or not your district subscribes to a policy service. So if you're in Illinois, do they subscribe to the press policy service? And so if you are in our text message here, you can press A for yes and B for no, and you can press C for I don't know. I have no idea what you're talking about, Jackie. So again, this is if you text Franczek to 22333. Once you join, then you are going to type A, B, or C. And it looks like what I would expect, which is that the vast majority of you are subscribing to and waiting for those press policies. Amy and I are working with some other attorneys with Marion Brotein and IASB on those, and they are expected to be out by early August. That's a long time to wait, but they will be out. At that point, you will need to still customize them to make sure that they fit with your decisions about how you want your policies to look. If you aren't waiting for those, in some ways, if you don't use them, in some ways it's liberating because you can just move forward on making policies for yourself that comply with the rules. And that's something we can help you with immediately, and you don't have to wait. If you don't know, I would suggest that you find out and then follow the track that we described for whatever the answer may be.
Yeah, and Jackie, I know one thing I know a lot of clients have been thinking about who do subscribe to press is, will they still be in compliance if their board doesn't adopt a policy until late August or September? Whether, they subscribe to press or just if they're thinking about their school calendar. Do you have thoughts about that, having been at OCR?
Yeah, so, actually I've known that I've known OCR to be frankly pretty friendly to school districts when it comes to things like their handbooks. So if you printed your handbook in June or over the summer, and then in November you received a sexual harassment complaint that required you to make changes to that handbook, OCR never, in my experience, required you to reprint your handbook. Frankly, in most cases, they didn't even require you to put anything out as far as a supplement. They just required you to come into compliance with your next printing. Now, that's not to say that I'm recommending that you don't do it. I think you should be moving forward. We have, as part of our toolkit that we're going to be putting out, we will have language for handbooks that you can use. We can actually provide that to you now if you're about to go to press, so reach out to us. But if for some reason you aren't able to get it taken care of at this point, you can always reference your website, direct people to go there, and then make the changes the next time you print.
Yeah. And I would just say, I think while we want to, as you've heard us talk about today, move toward compliance as quickly as you can by August 14th. But I would also say, if between August 14th and the time the board adopts a policy, if there is a gap and you do receive a complaint or a report, then you do want to make sure that you are following what is required under the new rules. And that's certainly a time when, probably more than ever, you want to be working with your legal counsel to make sure that you're following the appropriate steps. So, moving then, before we close, to talk briefly about training. The rules do contain express requirements for training, which must be done before August 14th, preferably. Although, again, as Jackie said, there may be some flexibility, at least in practice, by OCR, even if not stated. But regardless, each individual who is required to be trained under the new rules must be trained before they carry out that role under the school's policies and procedures. So let's briefly walk through what training is required and how you can get it done by August 14th. So for coordinators, investigators, decision makers, and informal resolution facilitators, they all must be trained in these areas on the definition of sexual harassment, the scope of the school's education program or activity, how to conduct an investigation and the grievance procedures, as well as how to serve impartially, including by avoiding prejudgment, conflicts of interest, and bias. Decision makers must also be trained on any technology to be used at a live hearing if live hearings are going to be offered, which again, those are required for K-12 institutions, as well as issues of relevance of questions and evidence, including when questions and evidence about the complainant's sexual predisposition or prior sexual behavior are not relevant. And regardless of whether or not you offer a hearing, that second bullet point does need to be involved in, included in the training for decision makers. And then investigators need to be trained on issues of relevance to create an investigation report that fairly summarizes relevant evidence. Now, we will be providing a training and are providing that can be tailored to your district, including via Zoom this summer if you are looking for a way to get this done. And our trainings will incorporate the required elements for the trainings that are expressly identified in the rules, as well as best practices that we recommend.
Right, and then this, for Title IX coordinators, K-12 employees, and officials with authority, we're recommending that you do an additional training. It's not required, but these individuals need to be able to spot sexual harassment and to know that they need to report it and how to report it. And remember, again, this is covering all of your employees under K-12. You might be thinking about having your Title IX coordinator do this training, and that's great, but they do need to go through the training themselves as well. So it either needs to be woven into the Title IX coordinator and investigator trainings that you're doing, or you're going to need some kind of train the trainer training to allow that Title IX coordinator to sit through that these issues. And again, we can help you with all of these trainings. We have them that we can pull right off the shelf. So contact us and we can tailor them to your districts and policies and procedures. And with that, we are at the end. I know we went a few minutes over. We don't currently have any more questions, so we'll sign off. But if you do have any additional questions that come up, please feel free to reach out to us. You can find our contact information on the slides, and you can also always reach us through allmarketing@franczek.com. Thank you so much, and have a wonderful day.